Kendrick Cole was 43 years old, a licensed general contractor who had spent 18 years building things for other people, and the last 4 building the company that bore his name. He kept a mechanical pencil clipped to the collar of his shirt on most days, and a tape measure on his belt even when he wasn't going to a site, because the habit of measuring before you committed to anything had served him better than most other things he had learned in the field. He drove a white work truck with Cole Construction stenciled on the door in plain black letters. He was not a man who revised his estimates after signing the contract. He was in a mediation room on the 11th floor of a law office downtown when he heard his wife, Lydia, lean toward her attorney and say, in the compressed voice of a woman who has run out of patience with a process she thought she had already controlled, "Just sign it." He's going to sign it. He had been reaching for the pen. He put the pen down. He picked up the document instead. What he read in the next 6 minutes changed the shape of everything that had been arranged around him. Before we jump into the story, comment where in the world you are watching from and subscribe, because tomorrow's story is one you need to hear. The mediation room had the spare, neutral quality of a space designed to belong to no one. Gray walls, a rectangular table, 6 chairs. A window showing a flat October sky. The kind of room where the architecture communicated, without saying anything, that what happened inside it was intended to be final. Kendrick had been in rooms like it before. On a job, the final walkthrough before the owner accepted the building had the same quality. A room where decisions made earlier were now permanent, and the only question was whether the work was what had been agreed to. He had arrived early. He always arrived early. The agreement had been in preparation for 3 weeks. His attorney, a woman named Patricia Lane, who was 62 years old, small and direct, with 31 years of family law behind her, and the specific patience of someone who had learned which battles needed to be fought and which needed to be watched, had reviewed the draft twice before this morning. She had called him the previous evening. "Read the whole document before you sign anything," she had said. Not a summary, the document. He had said, "I always do." She had said, "I know. I'm saying it anyway." He had not known, sitting in his home office the evening before, what she had found in her second read that was making her careful. She had not told him. She had simply said, "Read it." Lydia arrived at 9:04 with her attorney, a man named Douglas Fitch, whose posture had the quality of someone whose confidence was built on an outcome he had already secured in his own mind. Lydia sat. She opened the folder in front of her. She did not look at Kendrick for the first several seconds, and when she did, she looked at him with the expression of a woman who had prepared for a transaction and was focused on completing it. The mediator, a retired judge named Harrison, who ran these sessions with the specific economy of a man who had heard every version of every story, opened the session and walked through the agreement's outline. Asset division, property, business interests, accounts, standard language. Douglas Fitch placed the signature copies in the center of the table. Kendrick reached for the pen. That was when Lydia leaned toward Fitch and said it. 3 words. Compressed, certain. The voice of a woman who believed the room had already been settled, and this was the final formality. Just sign it. He's going to sign it. He heard it. He had spent 18 years on job sites and had developed, without intending to, the particular auditory attention of a man who had learned that what people said when they thought he wasn't listening was almost always more accurate than what they said when they knew he was. He set the pen down. He picked up the document. He read from the beginning. Page 1, Clause 1, all the way through. Harrison waited. Fitch waited. Lydia waited, with the specific stillness of someone working hard not to show impatience. He turned to page 7. He stopped. He read the clause twice. Then he set the document on the table and looked at Patricia. She was already looking at him. She gave him the smallest nod, the nod of someone who had been waiting for him to reach page 7. He looked at Fitch. He said, "I need a few minutes with my attorney." He would mark that October morning as the day he learned the difference between the agreement on the surface and the agreement underneath it. Kendrick had come to contracting the way most good contractors did, through the work itself. He had framed houses at 22, poured concrete at 24, run his first crew at 27, gotten his general contractor license at 30. He had started coal construction at 39 with 2 employees, a truck, and a client list built entirely from people who had watched him finish something on time and called him when they needed something else finished. He drove the white truck because the truck was the business. He kept the tape measure on his belt because a contractor who didn't measure was a contractor who was guessing, and guessing was how you built something that failed. He was the kind of man who, when a subcontractor told him a phase was done, walked the phase himself before signing the completion report. He had learned that this made some people uncomfortable, and had decided he could live with that. The building would stand after the discomfort was forgotten. He had married Lydia at 36. She was a commercial interior designer. She made the insides of buildings into things people wanted to be in, and she was good at it, and he had admired the skill with the specific admiration of someone who understood what it required. He had seen the work from both sides. He built the shell. She made it livable. And for a few years he had thought that was a reasonable metaphor for what they were to each other. He had, in the first 3 years of their marriage, co-signed 2 business loans for her design firm. The first was $85,000. Startup capital for equipment, and the first studio space. The second, 18 months later, was $140,000 for a second space and 2 additional staff. He had signed both loans as a co-borrower because she had needed his credit and his signature, and he had believed in what she was building and had not thought of it as risk so much as investment. He had not been named in the design firm's ownership documents. They had talked about that at the time and agreed it made more sense for the firm to be hers alone, professionally, and he had accepted that reasoning without examining it more carefully. He had also, in the first year of the firm's operation, spent 11 Saturdays doing the build-out of her first studio space himself. Framing, drywall, electrical rough-in, finish work. Because the general contractor quote had come back at $62,000 and he could do it for materials. He had done it. The materials had cost $8,400. He had not charged for the labor because the labor was his and the firm was hers, and he had believed those 2 things were part of the same thing. He had built her studio with his hands, and then co-signed the loans that paid for everything inside it, and then accepted that his name would not appear on the ownership documents of the thing he had built. He had accepted all of that without examination, because accepting things without examination was, he had come to understand, his most expensive habit. The year before the mediation, he had noticed the accumulation of small changes that were individually explainable and collectively something else. The way she talked about the business in the first-person singular when she had always used the plural. The client calls she took in the other room. The weekends she spent at the studio that started extending without advance notice and ended without a count. He had told himself she was growing. He had told himself the business was in a demanding phase. He had extended those interpretations across 12 months without asking the question they were substituting for. His site superintendent, a man named Claude who had worked alongside Kendrick for 11 years, and who had the specific directness of someone who had earned the right to say things plainly, had said to him once while they were walking a finished floor, "You know what I've always respected about you? You never sign off on something you haven't walked. Most people in your position would trust the report. You walk it every time. He had looked at Kendrick. You should apply that to the rest of your life, too. Kendrick had said, I thought I did. Claude had said, almost. That was what Lydia had not understood about the man sitting across from her in the mediation room. She had trusted that he would sign what she had put in front of him, because she had built the room around the assumption that he would. She had been wrong about the man. The small room adjacent to the mediation room had 2 chairs and a table, and the specific quiet of a space where difficult information was exchanged between people who needed to be honest with each other without an audience. Patricia closed the door. She sat. She opened her copy of the document to page 7 and set it between them. Page 7 contained a subclause within the business interests section. The main language of the section addressed the standard division of business assets, Cole Construction, valued by a mutually agreed appraiser at $1 million, with Kendrick retaining full ownership in exchange for a cash payment to Lydia. Standard expected the subclause was 3 sentences. It concerned ancillary obligations associated with jointly held financial instruments. The language was dense in the way that language is dense when it is designed to communicate one thing to a casual reader and another thing to someone who reads to the bottom. Patricia had read to the bottom. This subclause, she said, pointing to the 3 sentences, purports to assign sole responsibility for the outstanding balances on both co-signed business loans to you. The first loan, $85,000, with $61,000 remaining. The second loan, $140,000, with $128,000 remaining. Kendrick looked at the numbers. He looked at Patricia. She's asking me to assume $189,000 in debt, he said. She's not asking, Patricia said. This language, if you sign, makes the assumption binding. Her firm carries the loans. You carry the liability. She paused. Her attorney drafted this to look like standard language about financial instruments. It is not standard language. Kendrick picked up the document. He read the 3 sentences again. Then he set it down. She co-signed those loans with me, he said. Jointly, Patricia said. Yes. What this clause attempts to do is quietly transfer your joint liability into sole liability, buried in Section 7 of a 14-page document, at a signing meeting, where the expectation was that no one would read it carefully. He looked at his hands on the table. When did you find this? He said. Last night, she said. Second read. I called you because I wanted you to know to read the document yourself rather than because I wanted to alarm you before you'd slept. He thought about the previous evening. He thought about her voice on the phone, steady. Careful, I know. I'm saying it anyway. He sat with the information for a moment, the way he sat with a site assessment, when the numbers didn't add up. Fully, without rushing toward the next step, allowing the full picture to settle before deciding what the picture required. There's one more thing, Patricia said. She turned to page 11. The design firm's current equity. She has listed it at $340,000 in the asset declaration. I had our forensic accountant run a valuation independently. She placed a separate page on the table, 2 numbers side by side. $340,000 is the declared value. $710,000 is the appraised value. The room was very quiet. She declared the firm at less than half its actual value, Kendrick said. Which would have affected your cash settlement for Cole Construction, Patricia said. Because the 2 business valuations were intended to be offsetting. She takes less on paper. You pay less to retain your firm. Except she doesn't actually take less, she takes the firm at its real value. You just don't know that's what happened. He stood. He picked up both pages, the subclause and the valuation comparison, and held them. He understood the structure of it now completely, the $189,000 debt reassignment buried in the language of Section 7, the design firm undervalued by $370,000 in the asset declaration. The two pieces working together like load-bearing elements in a calculation that only balanced if you didn't examine either one closely. She had built something. She had built it precisely. She had just built it in a room where a man who walked every finished floor before signing the completion report happened to be sitting. He walked to the door. "Tell Harrison we need 30 minutes, he said, "and tell him we have concerns about the document." He didn't move fast. The 30 minutes became a working lunch, became a full rescheduled session 3 weeks later, because the concerns about the document required the kind of response that a 3-week preparation produced and a 30-minute hallway conversation did not. Patricia engaged the forensic accountant, a man named Raymond Goss, 58 years old, former EARS senior examiner, who had the unhurried precision of someone who had spent 20 years finding the thing people hoped wouldn't be found, for a full review of the design firm's financial records for the prior 2 years. Lydia's attorney objected to the scope of the review. Patricia cited the valuation discrepancy and the case law on asset disclosure accuracy and held her position. The review proceeded. Raymond worked for 11 days. He called Kendrick on a Tuesday evening at 6:47, not because 6:47 was a convenient hour, but because that was when he had finished reading the last file and had something definitive to say. What he found in the prior 2 years of the design firm's records was a pattern that the appraised valuation had suggested but not specified. $83,400 in revenue that had been recorded as deferred, pushed into future reporting periods in a way that reduced the current period balance the valuation appraiser had used as its basis. The deferral was not fraudulent on its face, but it was structured in a way that its timing corresponded precisely with the months during which the divorce proceedings had been initiated. "Someone advised her to move these numbers," Raymond said. "This is not an accidental accounting decision. The timing is not a coincidence." Kendrick sat at his kitchen table, the same table where he ate breakfast every morning, in the house that was still technically the marital home, but had taken on the quality of a place whose chapter was closing. He thought about the $62,000 contractor quote, and the $8,000 in materials, and the 11 Saturdays. He thought about the co-signatures on $225,000 in loans and his name nowhere on the ownership documents. "What does this do to the valuation?" he said. "If the deferred revenue is included in the current period basis, which it should be, under standard valuation methodology, the appraised value rises." Raymond paused. "To approximately $710,000. The declared value had been $340,000. She declared the firm at less than half what it's worth," Kendrick said. "That is an accurate summary of the situation," Raymond said. Kendrick set the phone on the table. He looked at his hands. He thought about load-bearing calculations, the way a building's structure could appear sound from every visible angle and still be carrying its weight incorrectly, the error hidden in the numbers rather than the material. He had caught those errors before. He had caught them by reading the calculation rather than trusting the appearance. He called Patricia at 7:15 and reported everything Raymond had said, in the sequence Raymond had said it, accurately and completely. Patricia listened without interruption. When he finished, she said, "Good. I'll call Fitch in the morning." Fitch called back in 40 minutes. His voice, Patricia told Kendrick afterward, had changed quality between the call going out and the call coming back. The revised settlement negotiation took 3 weeks. The debt clause was removed entirely, joint liability remained joint, as it had always been, and was resolved as part of the overall settlement rather than assigned. The design firm's equity was declared at the appraised value of $710,000, and the settlement adjusted accordingly. The deferred revenue was included in the valuation basis. Kendrick's cash settlement for Lydia's share of Cole Construction was recalculated against the accurate numbers on both sides. The difference between what he would have paid under the original document and what he paid under the corrected one was $241,000. He would think about that number later, about what it represented, about the 3 sentences on page 7, and the voice that had said, "Just sign it," in the compressed certainty of someone who believed the room had already been settled. He had signed the corrected document on a Thursday afternoon in November, 34 days after the mediation room. Patricia had handed him the pen. He had read the document first. He had read it from page 1 to the last page of the last exhibit. Then he had signed. It did not happen all at once. Cole Construction continued into the year after the settlement with the same crew, the same white truck, the same plain black letters on the door. Kendrick had 3 active contracts in November, 4 in January, 6 by the following spring. His name appeared on a regional commercial project in the second year, a mid-size office renovation whose general contractor he had been recommended to by a developer he had worked with twice before, through the kind of referral chain that builds over 18 years of finishing what you started. He answered every call the same day. He gave accurate timelines. He walked every phase himself before signing the completion report. Lydia's design firm had, in the year following the settlement, resolved the deferred revenue and carried the joint loan obligations that had remained joint. The business was still operating. She was carrying what she had chosen with the specific weight of someone who understood, now that the room she had arranged had not contained the person she had arranged it for. That understanding didn't leave a person. It settled in alongside everything else they carried. Claude retired in the spring. Kendrick kept him on as a part-time site consultant, 3 days a week, when he wanted to be there, for as long as he wanted. Claude had said, "I don't want to be a charity case." Kendrick had said, "You're not. I need someone to walk the floors I don't get to." Claude had looked at him for a moment. "You walk every floor." Kendrick had said, "I know. I want a second set of eyes." Claude had started the following Monday. Raymond Goss had sent, without explanation, a book on forensic accounting that Kendrick had not asked for. He had read it. He had found 3 things in it he had not known and wished he had known earlier. Patricia had sent a plant. Small, ceramic pot, no card. He watered it on Tuesdays. He gave accurate timelines. He drove the white truck. He kept the tape measure on his belt. On a Thursday evening in late March, 16 months after the mediation room, Kendrick sat in the cab of the white truck in the parking lot of a completed job, a commercial renovation he had just done the final walkthrough on, the last thing he needed to sign before the owner accepted the building. The lot was empty. The building's lights were on inside. The new fixtures his electrician had installed. The clean geometry of a space that had been built correctly and would hold. He had the completion report on the clipboard on his lap. He had read it from the first page to the last. Everything was what it was supposed to be. He signed it. He sat in the truck for a moment after. He thought about the mediation room. The pen he had been reaching for, the 3 words that had come through the gray air of a neutral space designed to belong to no one. He thought about page 7. He thought about the tape measure on his belt, the same one he had owned for 6 years, the same model he had bought to replace the previous one, which had served its purpose and been replaced with something that did the same job correctly. He put the clipboard on the seat beside him. He started the truck and drove home. I hope you enjoyed that one. Be sure to like the video and subscribe so you don't miss the next story. I've picked out 2 more for you that I think you'll really like.